data privacy by design. We're going to discuss a few other elements regarding privacy audits, and we're also going to discuss compliance and data sharing and data impact assessments. The whole idea of today's webinar is to make sure that startups and business leaders are able to understand the entire privacy framework, how they need to undertake privacy audits, how they need to build their systems, how they're going to have their privacy policy align with the data protection principles, the rights of their data subjects, and it's a whole breadth of learning that is necessary, and even being able to build compliance checklists for your organizations, and even for lawyers, because I have noticed that we have quite a number of lawyers in today's webinar, for you to be able to understand how you need to draft and build up some of the privacy policies and the data protection mechanisms within your organizations. Now, the first thing we need to discuss is why privacy matters for startups. Most of the startups and most of the businesses and most of organizations usually collect a lot of data. E-commerce businesses collect names, addresses, payment information. Even ourselves as law firms, and even when we were trying to set up this webinar, we did collect a lot of the user information that is present. We collected your emails, we collected your phone numbers, so that we can do follow-ups, we can share some of these agendas, we can share the links and all this information. So it is important for startups and for businesses within these various areas to understand the data that they collect is usually people's data, and there is principles and a set test that you need to undertake to make sure that you do not lose the confidence in the data that is present for these individuals. Now, for example, we have SaaS and technology startups that collect tracking data, logins, usage data, IP addresses, passwords. Fintech companies, they collect financial data, the ID numbers of individuals, the transaction histories, and even sensitive health records, biometrics. There's so much data that businesses collect that needs to comply with the regulations that are set. For example, we have, when you go to a hospital, you have to give your name, health data, your patient details, and all this information that is sensitive, and you need to ensure that you do not get bound to fail to comply. You do not ignore the rights of the data subjects and the people whose data that you're collecting, and even how you distribute that data, how you store that data, and the various contracts that you get into with the data subjects in order to protect them. So in Kenya, we have a legal framework that governs data protection. This is the Data Protection Act of 2019, and the regulator is the Office of the Data Protection Commissioner, the ODPC. And the current Data Protection Commissioner, the head of the organization is Kasait. And within this act, it regulates personal data, sensitive personal data, and registrations of data processors and data controllers. So ideally, what is personal data? Personal data is any information that is identifiable, that can be linked to a person. This is your name, your email, your phone number, your ID, your IP address, your location, your biometric data. If data can be linked to you, then it is personal data. Now, sensitive personal data are these very specific, health data, biometrics, financial information, religious belief, genetic data. There is some data that is very sensitive and personal. Now, a data controller is a person who determines why and how personal data is collected. more or less, this is usually the startups that you have, while a data processor is an entity that processes the data in behalf of the controller. These are usually the systems that you use, say Google Analytics, MailChimp for the people who do email marketing, AWS that stores data, and even Stripe that stores payment data. Now, in Kenya and most startups, you usually realize that you are both a controller and a processor. And there's both licensing and different tiers for the same. Now, we also have the core data protection principles that every startup must embed into your operations and into your data protection system. Now, the first principle is lawfulness. When you collect data, you should have consent and have a contract and an obligation or a relationship with the data subject. So you don't just collect data, it has to be lawful. And how do you make the collection of this data lawful? You need to have a privacy policy so that the data subject can consent to the collection of the data. Then we also have purpose limitation. So you do not just collect data for multiple purposes, but once you're collecting data, you need to collect data for a specific purpose, and you then give information to the data subject that, hey, look, we're collecting your data for this purpose. If I'm collecting your data for marketing reasons, I will have to inform you that I'm collecting this data for the reason of marketing purposes. If you notice, for example, in the privacy policy and within the Google form that we used to register for this webinar, we had a question that we asked you. We asked, would you like to receive promotional or marketing messages from our organization? So for the people who ticked yes, we get to forward them and send to them our newsletters, our blogs, and our information communication, and things such as the slides for this webinar. But if you tick no, that means that you have not consented to us sending to you information and such data. Then data minimization. So we only collect what is strictly necessary. That's a very important principle. If you get notice that if you want to sign up for a newsletter, most of the places they only take your email, because that is what is necessary for you to receive that newsletter, not your email ID, not your date of birth. And when you minimize the data that you're collecting, you get to respect the data subject's rights. Then you have accuracy. So when you collect data, you need to have that data accurately, and so that you can even have a correction mechanism for the data subjects. And there is a storage limitation. You should not retain data beyond the period that is necessary. So within your privacy policy, ensure that you explain that we're going to retain your data for this period of time, and we're going to have deletion of this data or anonymization of this data after a particular time. Then we also have integrity and confidentiality. You know, this is people's data, so you need to make sure that you have the proper safeguard, encrypt it, have access controls, and RBAC role-based permissions and authentication, such that the data is not accessible to every Tom, Dick, and Harry in your organization, but it is only accessible to the right people, and even during your data transfers, which we're going to cover next. Now, we have privacy by design. For most of the builders and the technology startups and startups generally, you need to have privacy by design principles within your building. Don't make your development be reactive. Make it proactive. So have a preventive approach and have privacy as the default, such that users don't need to request for privacy, but at the default and at the building of the system, you have privacy as the default. Then ensure that you embed privacy by design and into the architecture. Put role-based access system. Don't have everybody access every data and every aspect of your system. Role-based access control systems usually even enable your business operations to be more efficient. When you don't have a HR person having access to finance records and accounts records, it's prudence to build a system in such a manner. Then you should also have full functionality. Don't have false trade-offs. Don't force people to actually give up their data in order to access some of your features. Then have end-to-end security, so ensure that the security process is complete. There is no line or a break into the aspects that usually happen from the point of which an individual gives you their data up to the point where there's deletion of that data, the security of that data end to end. Ensure also that there's visibility and transparency. You open and accountable to your data subjects about the data that you're collecting, about the purposes of the data that you're collecting, about the usage that you're collecting. Then also have a respect for users' privacy. So ensure that you have controls that respect the privacy of your users. So now how do you implement privacy design? So you need to map your data, know what data you're collecting, where it's going to be stored, and why it's going to be stored, who can access it, and who can use it. So ideally, map that data, then ensure that at any one point you know who has that data. Is it cloud-based? Is it on-premise? Do you have a server? Do you have a vendor? Do you have an external vendor? So for example, by the fact that we are using Google Meet, we know that Google Meet has access to our data. They have access to our email data and the name that we're using within our data. So now within our organization, we have a limitation as to the people who get access to the Google Forms and the registration, who get access to the emails and the phone number, which you had provided during registration of the same. I see that there is a question.
Oh, sorry to interrupt, but I am seeing that I'm not the only one who cannot see your screen.
Apologies for that. Let me. I hope it wasn't for so long. Do you now have it?
Yes.
All right. So let me see if I can get it to full screen again. I'm having a bit of a challenge with my camera, so that I can also see. Give me a second. Okay, so right, let me then do a full screen presentation. All right. So can you see my screen now?
No, I think when you turned on the full screen is when it disappeared.
Okay. No problem. Let me then try to restructure that. And now is it okay?
Yeah, it's visible though not in full screen, but it's better than not having the screen at all.
All right, what I'll do is I'll try to zoom it, but I'll also share the slides after the presentation, worry not, for the people who opted in. All right, so now what are the bad practices in privacy by design? So having people auto-subscribe. So for example, when we took your data, we cannot limit you and force you to auto-subscribe to our data. What we have to do is we have opt-in and ask you, do you want to have this? And ensure that you have minimal sign-up fields and only have the sign-up fields that are relevant and important to you. Then another important thing is ensure that you encrypt your systems, encrypt your databases, have secure authentication, protect your APIs, because now APIs are probably, unless if you're using external APIs, so you know the security is handled by somebody else, ensure that you protect that, have rate limiting and have authentications. Then RBAC, ensure that people have the least access and the least privileges within your system. Then also ensure that you have checkpoints at every release. Yeah. Now, now we also have data protection impact assessments. So the Act ensures, the Act provides that we need to have data protection impact assessments. This is a risk assessment that you need to conduct before you launch a product or a feature that can pose a risk to individuals. So ensure that within your organization, before you do a product launch, you ensure that you have a data protection impact assessment plan. See, if you're collecting biometric data, if you're profiling users, if you're taking GPS data, if you're having loan approvals, financial data, health data, CCTV aspects, and all those aspects of that data, make sure that you have an impact assessment. So how do you do an impact assessment? One, describe your processing, yeah, and then you assess the necessity that you're having, you identify the risks, and you implement safeguards, and then you sign off. It's just a simple checklist that you need to do within your organization. Ask yourself, what data are we processing? Whose data are we processing? Do we have to process this data? If we do have to process this data, then what are the risks that we're having? Then what are the safeguards that we can take to prevent the loss of this data, or the compromising of this data? And then you have a sign off of the same. Now, ideally, if you want to understand data impact assessment, for example, in a ride hailing app, this is what you would do in ride hailing app like Uber or Bolt. Just describe what data you're collecting. So within the data that you're collecting, you're having GPS, you're having GPS of two people, the driver and the passenger. Then you also have what risks are there when you're processing GPS data of people. So you can have people get stalked, you can have people get abused, you also have location history being accessed, and also you can have the employees of the startup or to the ride hailing app having access to location data. So for example, if you have maybe, I think the most common example would be like a Vengeful X, who can have who being an employee of Uber and having access to an Uber account may have the access of user data. So you being the founder of Uber should ensure that the safeguards that you put, of course, for example, let's first of all go to necessity. Is location data necessary? Yes, it is necessary. Is retention necessary? No, it is not. So now, if you want to have safeguards, and we know that maybe an employee might have access to this data, what can we do? We can mask locations. We can encrypt this location data. We can limit the employee access through the role-based access systems, the RBAC, and then you can also auto-delete precise logging after a few days. So then you have now a sign-off and a review process. Now another interesting concept would be something like Strava. So with Strava, there's the location sharing that occurs. Now, what you need to do is, what you notice with Strava is that they try to limit or hide the start point and the end point of that data. But nonetheless, it is still identifiable data. Now, you also have to know that safety starts with you. And I would also like to recommend an interesting video by Kuru. He just posted it very recently in some mini series. He did like a 5-day walkthrough of an individual who posted on his status and his work and his running and his travel on the locations that he has been with. That is actually a risky behavior on making your data identifiable to people online. Nice. I think you saw that. It's important. Just go check out Mkuru. That video will help you understand and see the risks that we put ourselves through. Now, we have something else called privacy audits. So privacy audits is where within your organization, you need to check out the compliance that you have been doing. So ideally, an audit is just a review of how your organization has been doing. So now a privacy audit is a systematic review of how your organization collects the data, uses the data, shares the data, stores the data, and destroys the data. So you need to benchmark the process or that process within your privacy policy as against the actual process in how you're doing things. So review whether it meets the Act's requirements and the regulations of the sector and the privacy policy. So now ask yourself, are we processing this data lawfully? Is our process undertaking purpose limitation? Is it aligning with the principles of data collection? Are we adhering to the rights of these people? Then undertake a technical audit. So this is mostly doing quote unquote cybersecurity assessment of your systems. So how are your encryption standards? Who has access? Do you have penetration testings? Do you have incident reporting aspects? When you do you have rate limiting? Do you have people who can protect your information? How do you handle things like DDoS attack? Then you also audit your process. So now, how does data move from entry to exit within your system? Do you have IT tools that you're using within your organization that can compromise user data? So, for example, one very interesting thing is that most of the digital apps that we have on our phones have the ability to ask us, would you like to share especially social media, would you like to share all your contacts data with the platform so that it links you with your friends? But then now you get to realize that, say you have like 1,000 or 2,000 contacts, you've just outrightly given maybe Google 1,000 phone numbers, maybe you have like 30 or 40 emails and their names and identifiable data because you opted in to that form of data collection. So you need to do an audit of your systems. So maintain an inventory, document the process, ensure that you even log the access of the data, have incident reporting, and also read through the vendor contracts that you're using. If you're having an ERP that you're using or a customer relationship management tool or a CRM, go and document and review and see what you have within that system. Do they have security certifications? How is their system? So it's ensure that within your audit, you conduct an audit even of the third-party software that you're using. Now, you also need to, ideally, these are just a simple checklist that you need to check. Look at your data inventory, what data you have, what are you collecting, why, do you have a legal basis for the same, what is your privacy notice, are you looking at the rights of your data subjects, how are you retaining data, and what are the security controls that you're having around that. Now, we also need to understand the concepts of data limitations and data minimization. We touched up on this a little bit. So ideally, purpose limitation means that we only collect data that is for the purpose in which we have collected it. So, for example, if you collected your email for the purpose of this webinar, I shouldn't be then using that same email for purposes of marketing to you unless I had asked for your consent to do the same and you had given me your consent to do the same. Then you need to define the purpose before the collection. So before I received your email through the Google form, for example, before you submitted the Google form, you had to put up a check form and say, yes, this is what I want, and this is the purpose for the same. This is the link to a privacy policy. This is how you need to look at it. Then you also need to do storage limitation. Ensure that you don't store personal data or people's data beyond the period that is necessary. And even now, you also have a collection limitation. So you limit the amount of data that you collect. Only collect what is adequate, relevant, and what is necessary. So audit all your forms that you have. Even for example, if you're having HR and you want to take up employees, why do you really need to know somebody's date of birth? Why do you need to know, other aspects that are not relevant to your to your HR process? Remember something like VMK versus Square. This is where they did not give a lady a job because she was HIV positive. So how did they even get to know that she was HIV positive? So that was also a data violation. So ensure within your organization, in order to avoid suits and all of these things, collect data within the proper principles of the same. Now, we also have data sharing and third-party processing. So usually, because of the nature of the digital world, we usually share a lot of our data, and we have that parties processing a lot of our data. For example, Gmail is a third party from Ruben Burro and Associates Advocates. So me using Gmail as a party is a third party processor. So now we have payment gateways, analytic tools, hosting platforms. These are various third-party processors that you have. So you need to go and look at the nature in which they process the data that they are collecting. And I remember a while back, data was called the new oil, because if you had access to users' data, you had the ability to you had the ability to manipulate a lot of information, and you had a lot of basically data is way too valuable just to be used anyhowly. And I think it's also important to go watch out interesting movie about the Cambridge Analytica scandal, where they used social media data to kind of like use mass control of individuals and mass control of people to vote for Trump. And there was also rumors that the former president Uhuru Kenyatta also employed the same company to sway the minds of voters who are on the digital space. So now you need to be very aware the third parties that are using your data, how they are processing the data, what is the scope of confidentiality, and the aspects of deletion, and all of those elements. Now, we also have cross-border transfers of data. So now, sometimes data transits borders. Now, the challenge or the realities with the internet, data is always transferred in various jurisdictions. Because the cloud hosting services, the email services, there's a lot of cross-border data transfer that occurs. Now, there's various aspects of the act that are important for you to notice. You need to ensure that you have defined contractual clauses with the recipient. You need to verify the data processing terms of the vendors of AWS, Google, ensure you assess even the countries, and even ensure that there is international transfer safeguards. And while you're doing this, ensure that you are aligned to the rights of the data subjects. Now, the rights of the data subjects are very simple. You have the right to access, right to collection, right to erasure, right to object, and right to data portability. So you as a data subject, you have a right to access your data. You have a right to correct your data if the data has been recorded wrongly. You have a right to request the erasure of your data, a right to object to the processing of your data or to the receiving of the marketing data, and you can even request data transfer. Now, for example, there's a lady who has been talking about a company on Twitter, dental hospital called Molars. So she was saying that what happened with Molars is that she went and did a test there and got imaging done. But when she tried to request those images to get a second opinion, they refused, and she was wondering, this is my data. So she has an opportunity to then sue or take them to the ODPC to get them to comply, or even the Ombudsman office for the act under the Access of Information Act to request their information and their data. There are various things that you also need to address regarding the security of your data, being the data breaches and how you manage a data breach. So now, When it happens that data has been breached within your organization, whether there is a hack or there's a data leak or there's accidental exposure or you've lost devices, you need to do a few things in order to protect the data that you have. One, contain the breach, whatever has happened. Then assess the situation. Then within 72 hours, you need to notify the ODPC, and you also need to notify the data subjects, and then you fix the problem. Most companies and most organizations do not follow this process, but it is mandatory for you to follow this process because you need to manage data breaches in the right way. Now I have that we also spent of time, and I want to have a few minutes for questions. So I will try my best to be done in the next 3 minutes. Now, these are most of the compliance mistakes that startups make, sometimes even lawyers make for their businesses. Now, people do a lot of investing, policies and privacy policies and terms and conditions. People also collect unnecessarily data. Sometimes they don't have consent records. Sometimes they don't have vendor contracts. They have no breach response plans, and they also retain people's data beyond a period that is necessary. So you as a startup founder or you as a business owner need to ensure that, one, make sure you have a clear-cut privacy policy. Ensure that you have the right consent requirements, because if you don't do it, you can easily get sued. And the ODPC has various penalties. The lowest that I have seen penalizing a business for data breaches was 75,000. The one that I have seen maybe is lower. I don't think so. The highest that I have seen is, I think, 3 million. Yeah, 3 million. Then statutorily, the highest that you can be charged is around 5 million for you violating the Data Protection Act. So you get to find that some businesses and some organizations violate people's privacy. The most common cases have been nightclubs, whereby people have gone as a reveler into a nightclub. Their picture has been taken, it has been posted on social media. Then the individual requests the nightclub, hey, look, I did not consent to my photo being taken. Please pull it down. Then the club is like, you know what, that's just your problem, and they don't pull it down. Then they are taken to the ODPC. Then they are fined. I remember, I think it's Casavera was fined around 500,000. Also, Embassy had a complaint. The Embassy on Thika Road had a complaint around the same issue. There are various nightclubs that have been had complaints because of their pictures. Now, I have seen a way that they are trying to get consent, or quote unquote manufacture consent, by putting up notices. However, some of those notices are not adequate, because you get to realize that you need to have informed consent. These guys are drunk, so you won't tell me they'll be able to consent. But even beyond them being drunk, you also need to understand that you did not give them an opportunity to object to the processing of their data, because you're giving the service with the expectation that they need their data to be. You're telling them that they can only get in and with the consent given. Now, the other thing that we need to understand is to do a compliance checklist for your startup. Do a data compliance checklist that would be a bit straightforward. Do a governance, operational, and a security checklist. Ensure you have a data protection policy or data privacy policy that is public facing. You have internal data handling procedures. Ensure that within your operational structure, you have either DPIAs when you're doing projects. You ensure that you have vendors who have agreements with you for data protection. You have an inventory of the data that you're doing. Ensure that even for the people who are getting access to your data, you have RBAC systems, the role-based access systems. Ensure that you also encrypt the data. These are the security measures at rest and in transit, and the RBAC system that we talked about. Ensure that you also have proper authentication measures, and ensure that you have user transparency, that the users know the data that you're collecting, why you're collecting this data, how it shall be processed, and they also are aware of their rights. Now, of course, there are various benefits of you being compliant. Your investor will like it. your customers will trust you. You will not be fined by the regulator. Then you will also have operational discipline, and you also have a competitive edge. For your business to look and become more professional, you need to have some of these things set up. You do not look like you start up with just a regular everyday shop. Now, we also have a simple action plan that we're just trying to think about. So the first thing that you need to do, one, register with the ODPC as a data controller or processor, do a data inventory mapping exercise, review your privacy policies, your cookie policies, have a designated data protection officer. You can outsource this to a lawyer. This can be internally. Our law firm offers the services of being a data protection officer, where we review your data protection policies, we draft your privacy policies, we ensure that the data collection is following the proper principles, that the users are aware of that they have. Then also build systems, ensure that you have privacy by design systems within your sprints, your product sprints as you're building. Ensure that the data rights, the data subject rights are requested, so that you can know that people can consent to their data, they can do the aspects that are required for their data. Ensure that your culture and your staff are aware of the data protection mechanisms and the processes that you do. Document your processes, have a retention policy, and then ensure that you have audits. This can be quarterly, and have reviews for the same. So as previously stated, our law firm is able to assist you with these processes. Now, data protection is a core business function. Just the key takeaways that we have from this webinar for you today is that you need to know that privacy is important for business. It's not just a legal checkbox. You can be sued, you can lose money around it, and it applies to you. The act applies to you, and your impact assessment will save you money. Make sure you have your regular audits, control your data sharing. Just at the end of the day, be very intentional about not just your personal data, but the business's data. And with that, I have come to the end of my presentation, and I would like you to understand that as the former Mozilla CEO, Gary Kovacs, said, that privacy is not an option. It shouldn't be the price that we accept for getting our services online. Now, with that, I would like to ask if there are any questions so that we can address them. Yes, Murima.
I hope I'm audible.
Yes, you are.
Okay, thank you for the presentation. I have like 3 questions.
Yes.
Let me just start with the one I've written down, like the most recently. You've given the club example. Is putting up notice that management is not liable to any privacy infringement through pictures or videotaping really binding?
Well, now you see that's an interesting question, because is management the one that is taking user data? Because if management is the one that is taking user data, maybe in terms of photographs, and you want to use them for your social media, that means that liability becomes to management. But if it is third parties without the consent of management, so for example, if an individual comes and takes their social media pictures with somebody else and then posts them, then liability befalls on the third party. But if it is management or third parties that have consent of management to collect that data, then it becomes a liability for management.
Okay, understood. And the next question is, say a startup has a research and development wing,
Yes.
where the data is actively collected for purpose of learning, so that the company can use it and also the other industry players can use it.
Yes.
Are there any specific compliance measures that apply for such?
Well, yes. Now, ideally, the Data Protection Act applies, and what you need to do is, one, get registered as a data controller and even a data processor, then have a privacy policy, ensure that the data subjects understand the rights that they have regarding the data that is being collected, the data that is being used, and how that data is going to be used, how long that data will be stored, the third parties who will access such data. If you're going to, it says for research, if you're going to have scientists in a different organization, all those elements are critical and you need to explain them to the data subjects.
Okay, understood. And my last question is, when executing data subject rights,
yes,
are the procedures given by the ODPC, or does it fall under the startup to create those processes? If a consumer raises a right to erasure, is there a process given by the ODPC, or does it fall under you as a startup owner to create that procedure?
Now, for data management, it falls on you as a startup owner to create that procedure. Reason being, you're the one who has collected this data, you're the one who has this data. So what the Data Protection Act provides is that you can either have erasure or anonymization. So anonymization means that this data does not become identifiable towards a user, and you can still do erasure. But when a data subject requests for you to do erasure and you do not do it, and they can prove that you have not done erasure, they can then come and sue you for not abiding by their rights.
Okay, well understood. Thank you.
All right. Now I also see another question by Philip in the chat box. Hello, what if a subscription model requires the mandatory 7 years of retention by KRA, but the client requests for deletion? How do we avoid infringing their rights to erasure? So now that is a purpose. It's a purpose limitation, because you see the Constitution of Kenya. I think let me just go back to that, because that's the most basic of the laws that we have, and the law that gives all other laws validity within our country. So the Constitution of Kenya says that you can limit the rights of individuals based on a few things. One, whether it is proportionate to limit that right, whether there is no other way to undertake an action unless you limit that right. So now, when you have a mandatory retention by a different act of a particular period, what you have to do is you have to mandatorily retain, and you justify saying that within the Constitution, you can limit a right, but I think it's Article 23. It's 23. So within Article 23 or 24, one of the two. Within the setup structure by the Constitution, you can limit when you have passed all the tests saying that it is reasonable, it is proportionate. There was no other way of doing this, of retaining the data, unless we retain that data within that 7-year period. I hope that answers your question, Philip. All right. Yes, Lenny.
Yes, thank you, Ruben, for the good presentation and the very well outlined action plan for startups.
Yes.
I also have several questions, and I'd like to start with a clarification from one of the questions asked by Murima.
Yes.
She asked the question about whether the notices in nightclubs are legally binding, and you said if management is the one that's taking the pictures, they are liable. Does that imply then that it's actually legally binding, those notices?
Well, not really. So the liability, I think that's too legal a term. I think I used too legal terms. There were too legal. Apologies for that. So one, the notices are not per se legally binding, because the consent has to be given. It has to be open. There's elements of consent that must be given, whereby you cannot restrict access without limiting. For example, if somebody wants to get into a nightclub and they want to say that, I don't want to be photographed or get put into social media, how will they get in, whilst the notice just tells them that just please notice that the images for marketing will be used and taken here. So the ODPC has said that that notice is not really enforceable, legally binding, and that then means that for nightclubs you need to have a more stringent or more clearer system of protection. So what I have seen in people doing in some events, they even have tags whereby you get like a sticker that shows that if you have maybe an orange sticker, you do not want to appear in any images, so you put like an orange sticker on your clothes. But if you don't have a sticker, then you can appear in any image. So it's just you need to be very creative, especially within public spaces, around how you're going to get consent of your people who attend the event.
Okay, thank you for that. My next question will be on the privacy policies. One of the bad practices is copy pasting privacy policies. But how do we actually go about generating those privacy policies? Do we have to go through, let's say, outsourcing this to a data protection officer, or are there platforms online where you describe your process and the privacy policy is generated? How do you actually come up with a privacy policy?
Well, ideally, what we've done, because for us as a law firm, we've been hired by different organizations to draft for them their privacy policies and to also do a privacy audit within their systems. So what we do is we look at the processes. There are things that are clear cut. What the Act provides. The Act provides that the users must be informed about their rights. The Act provides that they need to consent. They need to have a purpose limitation for their data. So ideally, the best and most clear-cut way would be engage the services of a legal professional or a DPO. Now, if you engage the services of a legal professional, you can be able to get a clear-cut system of how to do that. But it doesn't. I've seen also Evelyn ask a question whether you need a legal background or an IT background to become a DPO. Now there's training. Anything in this world can be learned. You just need to know the consequences of the actions that you take, because even lawyers draft contracts and sometimes those contracts are not very good and not rock solid. So what you need to do is, one, if you want to do it by yourself, go through the Data Protection Act. Read it and understand it, and then draft the privacy policy in accordance to the requirements of the Data Protection Act. If you want to outsource that service, you can outsource it to a lawyer. You can outsource it to a certified data protection professional. There are various data protection or data privacy organizations that are there that undertake training. For example, there's an organization called the IAPP. I think it's the International Association of Privacy Professionals. So they have various certifications, such as a CIPE, certified, I think it's International Privacy Manager, that's CIPM. So they have various different certifications that are around the privacy regime. So somebody with such a certification would also be a good person to help you with doing a privacy system. So even if you have an IT background, if you do not have, even if you have an engineering background, a medicine background, but you want to understand privacy, are interested in how data privacy policies can be structured, you need to do that. But now you also need to think and go broad, because for example, the DPA Act applies in Kenya. In Europe, we have the GDPR. In US, we have their different regulation. In different African countries, you have their different laws. So within these different laws, there are different ways in which the acts or the privacy policies need to be managed. That's why I was encouraging looking for a lawyer, because a lawyer will be able to ask you the important questions and tell you, hey, look, you have clients in Asia, so you need to have a data privacy policy that is aligned to the laws of Asia. You have clients in Europe, you have clients in the US, you need to have a privacy policy that is tuned to that region as well. I hope that answers your question, Lenny and Evelyn.
Yes, to my final question, what are the the fees involved in getting data certified?
All right. So now for our organization, we legal fees and statutory fees. So for statutory fees, it depends. It's usually tiered depending on your annual turnover and depending on your they have different tiers. So the lowest tier when your annual turnover is less than 5 million, it's usually around 4,000. That is the government fees. Now for legal fees, don't like this talking about legal fees because sometimes you have to take clients on a case by case basis and whether they have retainer agreements. But the legal fees are also not very stringent or not very high. It's something that we are open to discussing. So the registration, the policies, and also the audits that you need to undertake and the impact assessments that you might need to undertake for your startup. What I will do is I will share my phone number right in the chat box and my email address in case anybody has questions that or who's interested with undertaking the process for their startup so that we can move on from there. So you can just shoot me a text message, shoot me a call, and then we can discuss fees. Right. So
All right, thank you. Yeah, it's okay.
Great. Any other questions? Evelyn? All right, Margaret?
Okay, thank you. I have two questions. I'm not sure if I'm audible enough.
Yes.
Okay, my first one would be actually on the legal considerations for AI. For example, if you're doing lending or you're in the lending industry and maybe you're depending on AI for your credit scoring, do you have like legal considerations that you should consider? For example, you might find that the AI might affect the fairness of some credit scoring for some people. In case you're sued for such an occasion, do you have like legal considerations that a fintech company should take?
Yes. So now the Data Protection Act in Section 35 talks about automated decision making. So the Data Protection Act says that you're limited, AI or quote unquote automated decision making should not be done for data subjects. So now if you're using automated or AI to do data scoring and loan management, yes, there is a risk where you might be violating the act. However, the beauty is that you can just add another step. Yeah. Sorry? All right, let me go. So ideally, what you can do is you can add another human layer. I'm breaking. Can you hear me? Hello, Margaret.
Yes, you're good now.
All right, great. So, what I was saying is that Section 35.
Hello again.
All right, let me turn off my video. Maybe it will help the bandwidth. Let me turn off my video. May help with the bandwidth. So, with Section 35 of the Data Protection Act, it limits that aspect of automated decision making. So, what you can do is you can have automated decision making, yes, but you need to add a human layer. So have another person who can cross-check the decisions by the artificial intelligence so that AI is not fully responsible for making decisions regarding your data subjects.
And dealing with the big data, having a human layer, that means it's an aftermath. It's just a reactive way, not proactive.
Yes,
is there a way I can get a proactive solution? Or maybe safeguard myself in case that happens, because we might not be able to avoid that, because like you said, data protection and security can never be 100%.
Yes.
But how do I shield myself?
How do you shield yourself from what exactly? Sorry.
If maybe a customer just tries to maybe they have a liability, they may not want to pay, like let's say a loan, and then they raise a case that I am not the one that I assigned myself this limit. How do I go about that?
Okay. You see, that's the thing. That's a whole different parameter, because you see, for them to take a loan from you, you need a contract, which is not really managed by the data process or the data security process. Because you see now, you got into a contract. I give you money, you pay back with interest. You see, that's a whole different legal parameter. Does that make sense?
It does, but we did not agree on the money that I availed to you. Remember, these are maybe mobile loans that are automatically disbursed.
You see, that's the thing, yeah. When you disburse mobile loans, you need to have a terms and conditions aspect. Now, terms and conditions are a contract, and you need to either have a digital signature, a way that they can sign or accept that, hey, look, I gave you this loan. These are the terms and conditions. These are the repayment periods. This is how we structured it. Yeah. So now that contract becomes the basis, because now that becomes a digital contract. It becomes the basis by which you're going to sue them to recover money from them.
Okay, if that's enough, that is the digital consent, that's okay, and the signature.
Yes, that's the digital consent and the signature.
Okay, my last question will be on the cross-border data transfers.
Yes.
For example, if the lending platform stores data on an international, maybe cloud platform,
Yes.
what rules apply for the data transfers, for the cross-border data transfers?
Yeah, no. So now cloud services and cloud services are usually a bit problematic. Reason because they are hosted in different countries, and there's usually the cross-border data transfers. What you need to do is to make sure that you review the terms and conditions and the privacy policies of the servers that you're getting, you're hiring, be it the cloud service provider, be it AWS or Google or DigitalOcean or the other server providers. Just go look at the terms and conditions by which, because you see, those terms and conditions are usually the contract by which you get into by that organization. Then you also review their privacy policy, see whether it aligns with the principles that you're having within your country and within your privacy policy, and then within the act. Then also you need to conduct the data impact assessment, DPIA, data impact assessment. So you need to check the risks that are there. Ask yourself, does this company or has this company been reported to have breaches? So it's basically like doing a due diligence process, the same due diligence process that you do, for example, if you're owning land or something of that sort.
Okay, well answered. That's it from my end. Thank you.
All right. Thank you so much. Thank you, everybody. Being aware and mindful of the time that we have spent in this call. I thank you for joining. I thank you for your questions, and I'm very glad that we've been able to have a very wonderful and informative session. Thank you, Harrison, as well, for attending. Beyond us educating and having this opportunity to teach, it's also an honor for our firm to have people learn and to be able to even have an understanding of what is going on. And we thank you as well. In case anybody else has one question, but anybody has the freedom to leave because of time. Any other questions? Right, Peter? Peter, you may go. All right, I think Peter has lowered his hand. Wow. All right. Thank you so much. Have a wonderful rest of your day, rest of your week. Happy privacy. I've put in my contact details in the chat box so that in case you have any other questions and you'd like to ask, you can send me an email and you can give me a phone call and we will give you assistance. Have a wonderful day. Be blessed.